Attorney Terrence Bradley testifying at Fani Willis hearing.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a we share space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it'll be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say. I don't have no files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? When you represent someone, you open a file in your office, and when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship, and so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we can spend too much time on this.
No, okay, Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it, yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of the practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So, just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023?
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to ask you.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that might not even have to change hands for that relationship. I'm making a finding because the evidence is already presented, namely the fact that he signed pleadings to the depositions on Mr. Wade's behalf, that attorney-client relationship did exist. At some point.
And I was just laying the foundation of the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that, but the questions I've heard so far are more from you were never paid ever, it was from an overall angle.
Well, from 2017 until November 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm, and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And are we friends? I mean, we were friends at the time, yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization and gone on through it, so I think this is asking it.
All right, I'll answer this one question overruled.
Repeat the question.
Did you, in your small firm, have occasion to where people would sit around and socialize and talk about what was going on in their lives, as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
Objection. Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life, about what was going on in your life and what was going on in his life, right?
Right. Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
All right. Sustain. Next question, Mr. Gill.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life? It had nothing to do with him asking you legal advice.
Objection. Be more specific.
I think he's just asked whether he socializes outside of legal advice. So I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing. The social life, did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Okay, Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out a legal advice, not talking about something that might be personal or confidential, and that's the distinction that I would draw.
I think that's an accurate legal point. However, I think the witness has already been questioned and testified on this point.
Thank
you.
You.
Next question.
Now, you got in the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussion, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we.
Objection. He's asking about interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client as well.
Mr. Young?
Well, I don't think it's the attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them, and did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content.
Objection.
You had all of that knowledge and information. I'm sorry, let me get my question out.
That's what I was trying to say.
He objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's the follow-up question to that is going to be incorporating knowledge learned during communication. So
No, I'm not going to have a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
okay. In which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay. I'm still asking the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
So what if the question was, did you when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered under privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block public dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which have been made by your client in the divorce case?
No.
Objection.
Okay, so that's going to cover communications during the relationship.
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll still say no objection.
All right. Thank you, Your Honor. That's all I have.
Thank you, Mr. Gill.
Thank you.
Mr. Kucherov, are you still with us?
As you leave the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you for watching.